All right, it's 2 minutes past the hour. I think we should begin and others can start trickling in. My name is Dan Frier, and I will be the moderator of today's presentation. I have been practicing healthcare law for about 29 years. It's hard to believe. I was only 12 when I started. And in the 29 years I've been doing this, I would say that the aesthetic industry is one of the hottest industries I've seen. I've seen a ramp up in this industry that I really haven't seen in too many other healthcare industries. And we have been involved in the aesthetic industry for many years, kind of readying ourselves for this moment. We thought this topic would be of interest to some of our contacts because there are a lot of questions that we get. We recently spoke at a conference. Brandon and I recently spoke at a conference. We got a lot of interesting questions. Some of you may have been to that conference. We're going to provide much more information in this webinar than we provided at the conference. And we look forward to any questions you have. You can submit your questions in writing, and we will try to get to as many of them as possible. If we can't get to them during the presentation, we will try to respond after the presentation. So I've introduced myself. I'm one of the two founders of Frier Levitt, which is a healthcare boutique firm. We operate nationally. We have locations in New York and New Jersey, but we really are a national practice, and our work within the aesthetic industry, plastic surgery, dermatology is really national. So we see a lot of things in a lot of different areas. My two co-presenters who will be speaking more than I will as the moderator are Brandon Zarsky, who's a partner at Frier Levitt. Brandon really focuses heavily on the aesthetic industry. We all do general healthcare law, so we see a lot of different things. We represent many different types of clients, but certainly Brandon and Antony have a significant focus in the aesthetic industry. As I mentioned, Brandon is one of our partners. He has really helped me develop this area of practice and has tremendous expertise. He does a lot of work with individual operators in different states, trying to figure out scope of practice rules for nurse practitioners and PAs, things like that, state corporate practice of medicine limitations, and helping our clients navigate all of those and many other issues. And then Antony Kamel is one of our younger attorneys who is also extremely knowledgeable in this area. He has gotten up to speed unbelievably quickly with this and is a phenomenal resource. He will be presenting as well, based upon a lot of the experiences that he's had and knowledge he's developed over the last couple of years. And I think we can now forward to my least favorite slide, which is the disclaimer slide. Just real quick, I have to say we are not representing anyone as legal counsel on this call. This is purely an informational call or webinar, and nothing that we say today constitutes legal advice. Okay, you can move on to the next slide. In fact, you can go past all these slides. Anyone who wants to read more about us, we're going to put this slideshow probably on YouTube. It'll be on our website, so you can always link to it and you can have access to it anytime you want, as many times as you want. You can read all this filler later on if you choose to. Next. Okay, next. Okay, so this is what we're going to talk about today. First part is private equity trends, preparing for a sale, and we're going to talk about why it's even relevant to talk about private equity, whether or not you're interested in a private equity transaction. We'll address various legal complexities, enforcement actions, and how to structure a legally compliant aesthetic business. We'll go through number 3, state-by-state issues. I mentioned earlier, scope of practice concerns. There are certain federal laws that impact aesthetics, but most of the laws are really state-based, because most of the work that actually all the work you're doing is really doesn't involve Medicare or Medicaid billing. So generally, you're not governed by some of the significant federal statutes like Stark or anti-kickback, but you are going to be subject to all the state laws that apply to all different kinds of payers. We'll briefly talk about the weight loss drug surge and what's going on. I mean, it's incredible. Eli Lilly, the maker of Mounjaro, I forgot what it's called now, they are now opening up telehealth clinics all over the country so that they can bypass traditional practices and avoid having to get their drugs prescribed by physicians for their patients. Patients can go directly to a telehealth portal. It's just an amazing trend. And then we'll talk about future outlook and additional trends we think are on the horizon. Next slide. I'm going to turn over to my partner, Brandon. Brandon, why don't you take it from here?
All right, absolutely. So, I think as Dan mentioned, the first thing we're going to be talking about today is sort of private equity trends and just sort of the business positioning and the economic positioning of aesthetic medicine, as we move from 2023 into 2024. I put a couple of stats up on the screen that I think are really, they exhibit what we're seeing as a huge market boom that has really started picking up. I mean, I would say probably about 10 years ago, then after COVID really just started absolutely snowballing. As it's noted on the slide, health and wellness spas revenues are at they were at 23.2 billion in 2022. That's expected to just keep growing and get up to 25.3 billion in 2028. I can tell you that some initial stats from an NBC report I read indicate that just the IV therapy, skincare, and cosmetic products, including your standard injections, were at about 15 million last year, and that's not including all the laser and different other things that were happening. So we're just seeing an absolute boom here. As you would expect in connection with that, one of the other things that's going on has been a huge effort by private equity firms and just larger consolidated aesthetic practices, medical spa franchises or networks across the country to continue to consolidate. And by consolidate, I mean they're essentially looking to buy up and add to their existing offerings, successful aesthetic practices and medical spas, weight loss clinics, IV therapy clinics, and the like, because they're looking to basically sort of try and take over the space to the extent that they can. For that reason, going forward, we really only expect consolidation to continue to increase as the revenues in this area continue to increase. One thing we did notice just from some market research is that one of the real target sellers, so the entities that these private equity firms and larger purchasers are looking to acquire, are successful medical spas and aesthetic practices that have multiple locations, including locations across multiple states. I think this is an important thing to note, because as your aesthetic practice grows and continues to spread, you actually continue to become an excellent target for some of the even larger groups that are looking to essentially use you as a platform for moving into certain geographic regions. Antony, you can move to the next slide. On that note, I'm going to hand it back over to Dan Frier just to let him talk a little bit about private equity generally, just to provide some background. If you are really interested in this space, Dan actually recently gave a few months ago a great webinar specifically about setting yourself up for a private equity sale. But with respect to just the aesthetic practice and medical spa angle, Dan, I'll hand it back over to you to let you talk a little bit about the complexities in this space and some things people should be aware of if they're interested in potentially entering into one of these transactions, or just if they're trying to build their business, as I think you'll get into.
Yeah, so as Brandon said, we have a webinar that we published onto YouTube that is a deep dive into how to prepare for private equity transactions for any healthcare business. It's not specific to aesthetic. If you have an interest, take a look at it. It is very informative, and it's close to an hour long. We're not going to get into that much depth here. The only thing I'd like to just emphasize is that when I have any clients that are forming a business, which we do a lot of work with startups, any client of ours that's forming any sort of healthcare business, whether it's aesthetics or any other business, I always like to have a conversation with them about what private equity looks for in a business, even if they have no intention of ever selling to private equity or taking on investment, because the private equity industry is essentially run by financial types, and financial types don't know how to run. They don't know how to run a healthcare business. They know how to evaluate it. They know how to take an existing business, look at it, and see whether it's valuable or not. And they look at certain factors in those businesses. And if you design your business to have the factors that these financial guys have in mind, then you will likely build a strong business. And so using the private equity model as a goal is smart because it will force you to think like a finance person and build a strong and durable and scalable business. And that's the value of it. The other thing I'll mention is that, you know, when you build your business from the very beginning, protect your brand, protect your intellectual property, protect it as if people care about it. When you first start your business, nobody cares about your intellectual property. Nobody cares about your name. You haven't developed a brand yet. But if your goals are satisfied, are met, you will establish a brand, and you will want to have protection for that brand. Protection can be registration of a trademark, copyright protection, possibly even patent protection. It could be non-solicitation or non-competition agreements with vendors that you do business with or with employees that you do business with, restrictive covenants, things like that. And all of that, if you dot your I's and cross your T's up front, then you have less to worry about in the future. Back to you, Brent.
Right. Thanks, Dan. So to add a couple of other things, we generally recommend to our clients and any business owner generally when it comes to the medical aesthetic space, and we'll talk about this a little bit later and some of the things that can happen if you don't do this, but probably the most important things to keep in mind are making sure that when you do set up the initial foundation of your business, that's going to be the business structure. And what I mean by that is you really need to structure your aesthetic practice so that it complies with the state that you're located in or the multiple states that you're located in, specific state regulations and laws when it comes to operating a medical practice. I should point out that in most states, in all states, most medical aesthetic treatments are considered the practice of medicine. Certain states will vary on certain procedures falling within or without that specific bucket. But if any of the procedures that you're providing or services you're offering fall within that bucket of the practice of medicine, then you are technically operating a medical practice. And that means that you're going to need to comply with state corporate practice laws. I'm sure many of you are aware of, the term medical director, utilizing a management services organization or MSO. Setting these things up at the forefront of your business operations is incredibly important because, one, obviously it avoids some of the investigations, potential regulatory issues that we'll discuss a little bit later in the presentation. But secondly, it's incredibly important because if you ever do plan on selling that business or you want to develop value in that business, potentially to pass it down to your kids or keep it in the family or whatever you want to do with it, you need to make sure that the foundation of that business is secure. That way, as you build on top of it, you don't need to worry about it all falling apart because you learn that you're operating improperly. God forbid the state attorney general shuts you down because you're not licensed to own a medical practice. You're not a doctor, physician, NP, depending on the jurisdiction. Another thing that I think is really important at the outset and something business owners should also consider when getting into this space, or if they haven't looked into it, something they certainly should, is making sure that their insurance policies also line up with the structure that I just mentioned. And by that, I mean, the medical entity is going to need to have professional liability insurance, and the MSO entity or management services entity, if you're using one, is going to also need to have, commercial and general umbrella liability insurance. You may want key man insurance on your medical director. You may want to consider having policies that cover both entities, and you also should consider how you handle malpractice coverage for the employees of the clinical entity. And by that I mean, does it make more sense for them to be under the policy of the clinical entity and add it onto it, or should they have to get their own insurance? And we could talk about this in much more depth. There's obviously a lot to be discussed about ways you can do this and the benefits and negatives of doing them certain ways, but definitely something everyone should consider. They should discuss with their insurance broker and potentially their attorney as well, just to make sure that everything's lined up correctly and that they're also in compliance with state insurance minimums for malpractice, for example. Antony, you can move to the next slide.
And I think it's important to understand and to remind everyone that when you own an aesthetics business, you essentially own a medical practice, or you're operating a medical practice. It's providing healthcare services, and you're subject to a different standard. You need forms like patient consent forms. If you're going to terminate a patient, you're subject to the state rules regarding terminating a patient relationship, which often require 30 days notice, often have other provisions that are required. So keeping that in mind, that you're operating a healthcare business that's highly regulated is very important. Sorry, Brandon, go back to you.
Of course. And no, I think, Dan, that's incredibly important. And once again, like Dan said, this stuff is all state specific. So it's incredibly important that if you're operating in multiple states, you make sure you're doing it right in each state that you're operating in. And then additionally, that you check it out to begin with and make sure that, for example, if you terminate a patient, you're providing them with proper notice. I mean, once again, like Dan said, you're operating a medical practice, and medicine is a highly regulated industry in the United States. So that being said, moving on to the next section of the slide, and this is sort of what I was referring to when I was talking about some of the bad things that can happen to you when you don't necessarily set your business up correctly or look into these things in advance. And that is the next topic, which is a little bit of a discussion on some of the 2023 enforcements and investigations that we saw pop up. There were a ton, and this is really just meant to exhibit kind of a growing trend that we've seen in 2023. But I'm going to hand it over to Antony Kamel, who's going to kind of give us some key points, updates, and examples of some enforcement actions across the United States in the medical aesthetic space, just to kind of try and tee off the next portion of our conversation.
Thanks, Brandon. So as Brandon and Dan had mentioned at the outset, the industry is obviously growing rapidly, both from a financial perspective and just the number of players in the space. So as more and more players are in the space, of course, there are more folks who are not complying with the law, and that results in additional actions, whether from state attorney generals, federal, the FDA, or state pharmacy boards. So recently, the FDA issued a warning letter about unapproved supplements and injections, warning consumers about certain popular injections that are being offered at different aesthetic practices, why they're harmful, the fact that they're not approved, giving links to approved supplements and injections, and really just warning folks about the harms of taking these injectables. On the other side, state attorney generals have slowly increased the enforcement actions done against non-clinicians providing medical procedures. So, for example, in New Jersey, if we just look at the last 3 years, the number of cosmetologists and estheticians that have started to do Botox or PRP injections or tattoo removal or laser hair removal outside of the scope of their license slowly increased year over year. And with that, the Attorney General has brought some enforcement actions against those folks and ultimately fined them and prohibited them from practicing further. So just as recently as 3 months ago, an esthetician in New Jersey was fined $22,000 and prohibited from providing further services. That esthetician was providing dermal filler, PRP injections, tattoo removal, Botox, laser hair removal. So it's very, very important for operators of aesthetic practices to understand who can do what procedure and who is doing those procedures. There are certain things that an esthetician can do within the context of a medi-spa, for example, facials or eyebrows or things of that nature. It's very, very important to differentiate between who can do the actual injections and to make sure those folks are properly supervised. Again, using New Jersey as an example, it's different in each state. So, for example, New York has different rules than New Jersey does, and especially businesses that are operating in multiple states, it's very important to sort of silo those different states and those different requirements because they can vary significantly from state to state. So just in terms of a future outlook on what we think is going to happen, obviously, as more and more of these businesses start to enter the market, you can expect the attorney generals of different states and different licensing boards to ramp up their enforcement actions. Of course, there's more businesses for them to regulate. And as Brandon and Dan had discussed early on, 10 years ago, this was a new space, right? As we progress into the years to come, it's going to become a more and more regulated space. People are going to take further action, and we'll address this later on, but certain states will start to introduce legislation specifically targeted at these businesses. I think Brandon had just mentioned it. but you are operating a medical practice. If you're operating a med spa or an aesthetic practice, there are certain intricacies that are just applicable to those aesthetic practices that leave operators in a gray area where they're operating within laws that are applicable to other medical practices. So I think what we're going to see going forward is going to be legislation that is specifically targeted at these aesthetic and cosmetic procedures. As a final note on this slide, there have been state pharmacy boards that have issued warnings about compounding drugs and drugs that are not in full supply. So if any practices are ever compounding these injectables, they should also be aware of those restrictions.
Yeah, and I think that's really important, especially I think in the IV hydration infusion space, and as well as the regenerative medicine space. I think that there has been a bit more of a crackdown by many state regulators. For example, like Antony mentioned, the state boards of pharmacy have definitely been cracking down on. I mean, there are some physical plant requirements for locations where compounding is performed. Think, the amount of airspace, the hood size, distance from doors, things like that, that a lot of medical aesthetic practices aren't even aware that they're subject to based on what they're doing. I think another really great example of this, we're seeing a big increase to, PRP, the amount of PRP that our clients are performing across the country. I think that a lot of my aesthetic clients are surprised to hear that they may be treated as a blood bank, or may be subject to specific state requirements requiring them to register as an exempted practice or something similar, if they are providing these platelet-rich plasma treatments, because they are technically storing blood fluids, and that makes them subject to these regulations. I think those are really great examples of just the complexity that this can really get into based on the services that you're providing. And I think it really drives home the point that it's extremely important that if, especially even if you have an existing business, you've talked to your attorney, you know that everything's set up correctly and good to go. As you add more service lines, I think especially in this day and age where we're seeing a ton more regulation in the medical aesthetic space. For example, some of these PRP regulations came out in the last couple of years, and we'll talk a little bit more about legislation in the next couple slides. But it's a great idea to just kind of check in every once in a while and make sure that as you add services, as you expand your business, as you move into new jurisdictions, that you're constantly making sure that the way that you're structured, the way you operate, is in compliance with the rules for your specific jurisdiction. One final note on this, and I think it's important to note, while most healthcare laws apply to businesses that get reimbursement from Medicare and Medicaid. FDA regulations with respect to utilizing drugs, and especially approval of drugs for certain uses or just for general use, apply across the board to everybody. One specific area where that FDA warning letter that Antony mentioned really dove into were unapproved, fat reduction injections. I'm not going to name any names, but there were a couple that FDA specifically pointed out in their warning level that were problematic because they weren't approved and were being utilized across the country in very high amounts. There was actually a recent, I saw an NBC investigation and interview where they were actually interviewing a couple of social media influencers from California who had gotten hundreds of these injections and now are having serious issues. The state attorney general got involved and shut down a ton of businesses. So these are things that are happening actively in the space, and things you should be careful for if you decide to move into those specific product lines. Antony, you can move to the next slide.
I just want to add one more thing, Brandon.
Sure.
You had noted this, but it's very important when you're adding a new service line to not only, one, see who can provide those services, and two, if there are any additional registration requirements. So the PRP is an excellent example. But on the other side of that, it's very important to know who can provide what service. And I've heard Dan and Brandon say this to clients all the time. Just because somebody else is doing it doesn't make it legal or right. So it's always important to see scope of practice rules and registration requirements.
Absolutely. And to add one final thing to that, one additional thing you should also be aware of is even if somebody can perform it, you should keep in mind who needs to be supervising them. So for example, if an RN can perform something, but needs to be supervised by an MD, DO, PA, or NP. You'll need to know that. And then in many jurisdictions, there's also limitations on the number of RNs that can be supervised by any given MD, DO, PA, or NP. And in some circumstances, even where the NP or PA is supervising, there may be supervision restrictions on, the amount of NPs or PAs your medical director can collaborate with, even if they have prescriptive authority or close to independent practice authority. So not to muddy the waters, and we could talk about this for, a whole presentation on its own, but just to kind of really point out, this is a complex space, and it's important that you give it the respect that it deserves, because otherwise you may be putting your business in jeopardy. All right, so this is just kind of just a quick breakdown of sort of how you should be kind of approaching this, like we discussed, and some of the issues and concerns that we're seeing. So first and foremost, setting up the practice, like I mentioned, that corporate practice of medicine sort of idea that in certain states, there needs to be a separation of a medical entity and a MSO or management services organization entity to allow non-clinicians to own the, have an ownership in the MSO, but working with the clinical entity that they then partner with through a management services agreement or administrative services agreement. We need to always be considering setting up the business correctly, and then, as we just mentioned, making sure we're complying with scope of practice rules. As we mentioned earlier, we're seeing a ramp up of enforcement actions, and that is both with respect to structural issues as well as scope of practice issues. So not only are state attorney generals getting involved because they're concerned that non-physicians are operating medical practices and shutting them down, but additionally, they're getting involved because even where the business may be structured correctly, the providers that are working at the site maybe are exceeding their scope of practice, maybe they're not properly supervised, or maybe there are, specific rules, like, for example, the PRP registration rules I mentioned, the state of pharmacy physical plant, or board of pharmacy physical plant requirements that we mentioned. All of those things come into play there. And then finally, as we continue to look forward, and this is based off of probably a trend of the last 3 or 4 years, we really start to see this ramp up. What we're seeing now is, state legislatures are actually starting to write laws specifically targeted at the medical aesthetic industry and the, just medical aesthetic practices generally. We're going to get to some examples, but this is something you really should be keeping an eye on. And you should definitely be in touch with a healthcare attorney that's keeping you updated on these things in your state, because, like I said, these are state specific rules. And as I think over the last 3 years, I've probably seen 10 different states that have added med spa specific rules in one way or another. Some of them, as we'll give you an example, are actually specifically targeted at medical spas and medical aesthetic practices.
Just real quick, Brandon, on the second note,
Sure.
It's important to note that the enforcement actions, we see them both in terms of the esthetician and cosmetologist that I discussed in the last slide, but also on structurally, there's been some enforcement actions about lay folks just hiring an MD or a DO, or any clinician for that matter, which is in violation of the corporate practice of medicine. So very important to utilize the MSO model, and then also to understand who's supervising who and who is practicing which procedure.
Right. And definitely check with your attorney, figure out what your state specific requirements are. There are states that do allow, lay people to hire physicians and things like that, but the vast majority have at least some restrictions on them. So now the next slide is going to kind of go through some examples that we've seen, just to kind of really drive home what we were talking about before. So one, just to talk about the potential structural issues, right? I know Antony had just mentioned structuring to meet corporate practice requirements is important. There are also some other structural requirements you should be aware of if you're using models like an MSO model, because you're not a physician, but you want to get involved in the medical spa industry, and you want to kind of own a management company that provides services to an aesthetic practice. There are specific rules that even apply in the case of management companies. So, for example, New York State prohibits management fees, which are a percentage of income or receipts from a medical practice. What does that mean? In practice, that means that in New York, you're prohibited from having a management fee that is a percentage of revenues. That's extremely important to keep in mind, because I would say, and Dan, feel free to chime in, but I think probably the structure we see the most, because it most easily tracks the business's growth, is a management fee based on a percentage of revenues. In New York, those management fees are prohibited by New York's fee splitting laws, which I think is incredibly important to keep in mind, because a lot of folks, when they put together their MSO models, just assume as long as it's a fair market value, commercially reasonable management fee, it should be fine. The management fee may actually need to be structured in a certain way. And I think there are specific rules for this in other jurisdictions like California as well. So definitely things to keep in mind as you structure your business. Antony, if you want to, or Dan.
I'll just mention the management fee is the topic of significant amount of conversation we have with our clients, because it's generally in everybody wants to essentially set up what we'll call a captive or friendly practice owned by an MD, and then to sweep all the profits out of that entity into the management company. And that's the business goal. And whether that can be achieved or not depends on the state regulations, and depends on the risk tolerance of the business owners. The management fee raises two basic issues. One is a corporate practice of medicine issue. If you're sweeping 100% of the profits out, does that invoke that state's corporate practice of medicine or fee splitting rules? And there may also be an issue because we'll probably get into this more later, that if the management company, the main business is marketing for the aesthetic services, and to the practice, which is owned by a doctor, and the doctor is paying an outsized management fee, might that be considered a kickback under state law? So these are the management fee is a significant topic of conversation. Go ahead, back to you guys.
Absolutely. And then moving on to some scope of practice examples here. And this one's specific to lasers, and an interesting one, because we certainly see a lot of practices in New Jersey that aren't complying with this, but just something to keep in mind to dive into really how deep this stuff gets, and how the minutia of specific New Jersey regulations or regulations across the country may create rules that potentially limit practices from doing things that are done across the board. And I think this applies to what Antony was saying before about just because somebody else is doing it doesn't necessarily mean it's okay. I think this is one that we probably see more than anything else in New Jersey, because I think almost everyone violates this. And I'm not saying that it's a good thing to violate it or that it's okay to violate it. I would say we see this a lot, and that is that the New Jersey definition of surgery means the manual or operative procedure, and then the key word there is including the use of lasers performed on the body for purposes of preserving health. So, and Antony, if you hit go again, it should show the next little tidbit on the bottom there. So based on New Jersey regulations, technically only physicians, and by physicians I mean MDs or DOs in New Jersey, can technically use lasers. I can't tell you how many med spas and aesthetic practices I know that have PAs, NPs, estheticians, or technicians using lasers. I'm not saying that those tomorrow the Attorney General is going to show up and knock on the door of those med spas and there's going to be a problem, but I think this is a great example of just because somebody else is doing it doesn't necessarily mean you're in compliance with the law, and B, that this is some complicated stuff and a lot of people are doing it wrong. So it's really important to try and figure out what these rules are to make sure you're doing it right. I think probably the two main reasons for that are, one, as we've already discussed, you don't want to get that knock on the door by state attorney general or the board of medical examiners. And then two, you want to make sure that your malpractice insurance policy is going to cover you. Or cover whoever's providing the laser treatment. I haven't seen it in this exact instance, but I can definitely say that we've seen a lot of instances where there have been scope of practice issues. There's been a provider that's providing something outside of their scope of practice, and their insurance policy essentially, there's an accident, somebody gets burned. or there's some other type of issue, and their insurance policy refuses to cover them because the insurance policy claims that they exceeded their scope of practice. They were essentially doing something they weren't legally allowed to permit, and therefore they're going to deny coverage. So, once again, I'm just using this laser thing as an example because I think it's one of the most widespread things we see. But as far as scope of practice and the minutia of what you need to be doing, who needs to be supervising it, and how everything really should run generally is something that you really should be considering, especially as enforcement ramps up in this space.
So I think something that's very important to note is that a lot of these things could potentially be changed by legislation specifically aimed at this industry. As Brandon had mentioned, in practice, we don't know how often a physician is firing these lasers. Again, this is the letter of the law, and these are things that could potentially be updated through specific legislation. And then another note is I just wanted to touch on how these enforcement actions really come to be. And I think they're in two major ways. First is the Board of Cosmetology doing random checks and seeing that somebody is practicing beyond their scope. And then the second, I would say, is patient complaints. If somebody's getting injured at the location and they put a complaint into the Attorney General's office, that could lead to a lot of the enforcement actions that we've seen.
And actually, that's an excellent point on the legislation, Antony. And I know we're about to get right into some legislation that came out a couple years ago in Connecticut, but I do want to note that for that New Jersey specific example, I think the PA board and the Board of Nursing are aware of it. And there was some legislation proposed to actually expand the scope of practice for use of lasers in New Jersey. I think it's still stuck in the Senate or it died in the state Senate. But there was a bill that we were keeping an eye on about a year ago that had made its way up to the health subcommittee, but then kind of got frozen out there. So we're still keeping an eye on that. But it just goes to show you that people are aware of this and trying to update it. And as Antony said, as the letter of the law currently stands, that's technically the rule. So just once again, an example of just making sure that it's important you keep an eye on updates in legislation, but also that you are aware of your scope of practice restrictions, supervision requirements, et cetera.
And unfortunately, this legislation, it's slow moving and takes a long time to become law, unfortunately.
Yep. So I think on that topic, the next thing I kind of going to go back to this topic because we talked about it a little bit earlier, and I think it's really, really important because we're starting to see this across the country. Connecticut, I think, is my favorite example just because it is just so clearly targeted at medical spa. I'm pretty sure the name of the law when it was proposed was the Connecticut Medical Spa Law. And so essentially what this law was directly aimed at doing, and I put one little part of it here because I didn't want to put the whole law up on the board, but it does a couple of different things. First of all, it creates some requirements that you have a higher level licensee. So for example, an MD, a DO, a PA, or an NP that's both, employed a member of or of the medical spa, that they're on site that there's at least one of these higher level providers on site at the medical spa. And then finally, that before any patient receives a treatment, that one of these higher level providers like an MD, a DO, an NP, or a PA does the initial physical examination and discusses with the treatment with the patient before they receive it, just to ensure that they're able to diagnose any contraindications or anything like that before the patient receives the treatment. I can tell you that a lot of my clients tell me that they think that it's just good practice to have one of those providers do the initial physical exam anyway. Many states have similar requirements to this, but I think this is just a key example of another thing that maybe a lot of aesthetic practices and medical spas may not be doing, or they may not be complying with their specific state laws. There's also obviously a huge aspect to this that is a clinical aspect. What is best practices for the patient? Can an RN or just a non-medical employee giving somebody a disclosure form, does that really meet the informed consent requirements for your state? Does that really get past all of those regulations that you need to comply with? And in the case of Connecticut, if you weren't having one of these providers do that initial physical exam, you'd be in violation of this law specifically. So once again, I like to bring this one up because I just think it's a great example of a law that is specifically aimed at the medical aesthetics industry, and we're continuing to see laws like this being proposed in different jurisdictions across the country and passed, as this industry continues to grow.
Yeah.
So
Yeah, Brandon, I think it's important to note as well that the law is the floor, if that makes sense. If we're going to talk about best practices, the statutory requirements are the minimum, right? If the goal is to reduce liability and ensure patient safety, it's important to use just best practices within the industry, and each mid-level provider's general best practices.
that's absolutely right. And something I can say we do on a almost a daily basis is advise clients on ways that things that may go above what they're legally required to do, but are intended to reduce the liability that they're generally exposing themselves to. And thinking about that is important because, once again, this is your business, this is your baby, this is, one of the most important things in your life, if not the most important thing. So limiting liability, making sure you're in compliance, that you structured everything correctly, protecting your brand, and setting yourself up to really grow value. These are all the things that, any medical aesthetics practice owner, med spa manager, anyone who wants to really be involved in this space should be thinking about constantly as we continue to see increased scrutiny and increased economic growth in this sector. I think we move on. So I also wanted to just briefly touch on the Biden administration recently instructed the FTC to propose a rule that would ban non-competition agreements. This is something that we could have a standalone discussion on, but I think it's important that people are aware of this. The rule hasn't been finalized yet, but we do anticipate that it will ban non-compete arrangements in most employment contexts. And when I mean that, I mean, a W-2 employee non-competes will be banned, and any existing ones will be required to be rescinded. This is key because, I think a lot of my clients utilize non-competes in W-2 relationships to try and protect their brand and protect their patient base. You definitely don't want one of your best injector employees leaving. To Dan's point earlier about protecting your brand, utilizing, branded Instagram or TikTok posts to, try and bring patients over to their new practice, reach out directly to your patient base, open up a place right next door. These are things that we think are pretty common, and they're commonly used for good reason to protect businesses. That being said, once they go away, I think we're going to see a lot of increased competition in this space. So protecting yourself in other ways, whether that's by really protecting your brand, having different employment policies regarding use of your IP. It's just another example of why you really should start considering these things, because as we move closer to this ban coming into place, assuming that it does, and things could always change, but assuming that it does go through, you may see a lot of your employees leaving and trying to compete with you. And, you need to make sure your brand is protected and you have other things in place to try to limit the amount of damage that could potentially do. So once again, I don't want to dwell on this, but I think it's just really important for everyone to be aware of this and keep an eye on it, because it could potentially have a huge impact on your business in 2024. All right. So I think this is probably the last thing that we're going to get a chance to touch on, and we're not going to do a huge deep dive on this because we're probably going to do a much deeper dive with one of our FDA experts and one of our Board of Pharmacy experts, later this year. But just so everyone is the title of this was kind of big things in the aesthetic industry and hot topics, and we wanted to make sure we touched on this because it's certainly a big deal. And that is, there's been quite a bit of controversy in the weight loss space in the last year. I'll turn it over to Antony to just kind of give us sort of a top three kind of explanation of some of the biggest things that have happened in the space, just to provide some examples, and then we'll talk about it just a little bit.
Thanks, Brandon. So in the weight loss space, multiple issues that have been really prevalent in this past year and will be going forward. One of those big issues is the shortage of these drugs and folks starting to compound these at their locations or at pharmacies. So State Board of Pharmacies have issued letters reminding pharmacies about their requirements for compounding and how to properly do that. Insurers have issued warning letters to providers about off-label prescribing. So that sort of is starting to change a little bit with the new drug Zepbound. And then finally, just warning letters from the manufacturers on proper proper prescribing of these drugs. As Brandon said, we plan to do a whole webinar just on this with our other experts at the firm. But we just wanted to touch on that because we'd be remiss not to discuss this, because this is what's on the top of everyone's mind in the industry this year, at least. So
Absolutely. And I think as Dan mentioned, we are starting to see new telehealth models that are being created to try and get around the prescribing requirements or make it easier for folks to prescribe these drugs, in a not in-person setting. So we'll continue to watch this. As Antony mentioned, we're planning on having more of a deep dive webinar later this year to kind of talk about this in a lot more detail. So stay tuned. If you're interested in joining us on that, we'd love to have you. But I'll leave it at that for now, because I think we could once again do a whole presentation on this. So Antony, if you want to just move to the I think this is the final slide here. So I do want to give us about 10 minutes for Q&A. But as we kind of finalize out this this presentation, I think I just wanted to touch on some of the things we should expect in 2024 and kind of bring that back to some of the key points that we discussed over the course of our presentation. So first and foremost, as we mentioned right at the beginning of the presentation, we've seen a huge boom in private equity interest in the space. And in addition to that, and something that we haven't really quite discussed, but I'm sure everyone is aware of, this is just a huge booming startup industry. We anticipate there to be a huge continuing growth in the amount of startups in this space, as well as an even bigger growth in the amount of M&A, private equity activity, and consolidation in this space. What does that mean? I think that means that for those of you who are considering a startup in the medical aesthetic space, please consider all the things we talked about today and the warnings that I think we've tried to issue on some of the increased scrutiny in this space. The next bullet point is we continue to anticipate there to be an increase on state attorney generals and FDA actions on drug usage, scope of practice, and how businesses are structured, especially at the state level. That dovetails right into the next point, which is that we are continuing to see and expect to continue to see more legislation aimed at regulating this space. I think in the last 6 months, I've probably seen more, in-depth like NBC investigations, interviews, bulletins by state attorney generals about the unregulated environment that is the medical aesthetics industry in many respects. I think that is a very good indicator that we're only going to continue to see increased regulation here. States are realizing that since the federal government is mostly not involved except with respect to the FDA aspects we've discussed, that they're kind of on the hook for regulating these things. And I think we're seeing that start to ramp up even more now. And finally, I think, just to dovetail into that, state boards are getting more interested in this. And I don't just mean the Board of Medical Examiners, as Antony and Dan mentioned, state board of pharmacies, state cosmetology boards, aesthetic boards, nursing boards. We've just seen an uptick in the amount of enforcement actions by boards, and especially where it's the unauthorized practice of medicine or exceeding the scope of one's cosmetology license. As a final note, I think that this really all just ties together on the one point that it's really key that whether you're a new and existing business, you both ensure that you're in compliance with the law now, but also stay in touch with what's happening in the space and, keep your ear to the ground and make sure you're aware of any legislative changes or key case law that might impact how these things work in your jurisdiction.
Yeah. Brandon, just to add something as well, in terms of the legislation, just the amount of introduced legislation that never made its way through is just an indicator of what's to come. And we'd also be remiss not to mention, I'm sure everyone at this point has heard what unfortunately happened in Texas of someone passing away at a med spa. And I'm sure Texas will be introducing some sort of regulation or legislation. And unfortunately, all it takes is one tragic incident to reshape the whole industry in your state. So these things change quickly. And they can change rapidly. So it's always important to just be in tune with what's going on. So you can look on the Frier Level website. We'll continue to update everybody about different legislation that comes through or different enforcement actions, all relevant whether you're new or existing.
All right. So I think we got a couple of questions here that have been submitted. Dan, I don't know if you have any that you specifically think we should touch on first, or
So a couple people asked if we could provide a link to the preparing for private equity webinar we did. I don't know how to send a link via this, but one of our marketing folks is on the call. If he's able to do it, he will. Otherwise, if you go to YouTube and you search for preparing for a private equity transaction, I think our video is like the second or the first video that pops up. And we also have a video that deals with how to form a management services organization that might be interesting as well. Again, it's a deep dive on the formation of MSOs, which is the key model for these types of aesthetic businesses. There, Jack's putting that up. If you do a search for management services organizations, I think we're the second or third video that pops up. These are all, informational. These aren't, marketing pieces. They're really deep dive informational pieces that you guys are welcome to access for free. I don't know if you have access to the other questions that have been asked, Jack or Brandon, but maybe you can read some.
Sure. So we got a number of questions, and I'm just going to combine these because we got about 3 of them. Is there a place that we can look up, what these aesthetic regulations are, the scope of practice regulations are, new updates on regulations and that sort of thing?
To answer that question, what you're really asking is how can you understand what laws you're subject to? And of course, as a lawyer, my knee-jerk reaction is to say, call a lawyer. It doesn't have to be Frier Levitt, but call a lawyer, because the concern I have is that unless you've got a legal background, legal training, you're going to make a mistake, and you're going to misinterpret the law. And the reason for that is the law is not in one single place. It can be in state statutes. It can be in state regulations. It could be in, guidance that's provided by state agencies. It's not easily found online. And so it can be tricky to get your hands around the law. It should be easier, honestly. I know that many of you are starting to use AI. I use AI. ChatGPT is not a reliable source yet. Maybe someday it will be, but it is totally unreliable and limited. It can be useful if you are an expert in something to supplement what you already know, but it's not useful if you're not someone who's trained to differentiate between what's real and what's false. It is improving, but right now it hasn't gotten to the level that I would ever advise anyone to rely upon it.
Yeah, and to add to what Dan said, for certain jurisdictions, in addition to regulations, statutes, guidance from regulatory agencies, a lot of state corporate practice of medicine requirements are actually built into case law. So if a case goes before a state Supreme Court and the court rules a specific way and puts factors down, those are probably not going to be available easily online. I mean, at Lexis or Westlaw maybe, and potentially you might be able to find them on, some certain state websites, but interpreting all of those things together is pretty tough. And unfortunately, as Dan mentioned, there's not a great repository for this information. And on top of that, a lot of these statutes and regulations can be extremely gray. And I can tell you, we've spent our careers, trying to interpret these things. So it's definitely not something I would recommend just trying to do on your own. But it's certainly something, you can talk to an attorney about. And if they're well versed in the healthcare laws of your state, they should be able to help you out.
Any other questions, Fran?
Yes. Any insight about anti-aging / medical spa franchises? Is it higher risk to do that or starting my own med spa weight loss business? So I guess is it easier to start as part of a franchise, or would it make more sense to just open your own?
I mean, it depends on the franchise. It depends on what they're offering. Are they offering marketing services? Are they legally compliant? And I say that with great seriousness, because many of these startups and franchise models are designed by franchise lawyers, not healthcare lawyers, and we've found significant issues with them. what are the resources they're providing? There are many instances where starting a franchise is the right choice for many people, is if it's the right franchise and the right model, rather than starting completely from scratch.
I just want to chime in about the one place for the regulations. Unfortunately, they come from so many different places. Like, you need to look at the Board of Nursing, the Board of Medical Examiners, Cosmetology Board, Corporate Practice of Medicine, that's really set forth in case law and in statute. So I wish there was a place I could just point you, but unfortunately, it's sort of synthesizing 4 or 5 different rules and regulations to come up with the proper business model.
Right. And I think, as we mentioned earlier, another thing that you should keep in mind is, even though those, like Antony, you said, those laws really create the floor. From both a legal and clinical perspective, it may be advisable to go above those to make sure that you're not exposing yourself to, a higher level of liability. I mean, there are certainly things that are legal, but a lot more risky to do. So it definitely makes sense to consider those aspects as well. I think we just hit 1 o'clock, so I don't, Dan and Antony, if you had any final comments.
No, guys, I just want to thank everyone for attending. We'll end now. If you have any questions, you can feel free to email us, and we'd be happy to continue the discussion. Thanks,
It was
everybody.
a pleasure, everybody. Thank you.
Take care.
Thanks.